My dear friends, and today's topic is Law of Torts. My name is K. Umesh Rao. In this class, we are discussing definition of tort, general principles of torts liability, theories of torts. Now, what is the tort? Torts is a French term that is equivalent of English word wrong. The word tort is a Latin term, tortum. It means twisted or crooked or deviation from straight or right conduct. The term tort was not popular till the middle of the 17th century. Tort action was commenced through a royal writ. Here, in this case, the plaintiff has to choose the correct or appropriate suit or writ and he has to pay for it. If he purchased a wrong suit or wrong writ, he could not fit his claim in one of the recognized forms of the action and his suit will be dismissed. This rule was called as ubi remedium ubi jus. Where there is no right, there is no right. It means if you don't file a case, no right. But today's maximum is not that. Today's maximum is ubi jus ibi remedium. Where there is a right, there is a remedy. The law of torts in India is based on the common law of England. It is linked with the establishment of the British courts in India. What is where there is a right, there is a remedy? What is the meaning? It is my duty to drive my vehicle very carefully, is it not? So I should not cause accident. If I hit a person, it means I failed my duty. Injured person has right against me to sue for damages. When I construct a house, I should take necessary precaution to avoid loss or injury to my neighbor, worker, bypasser. If some bricks falls upon the head of the neighbor and causes serious injury, I will be held liable. Supplier food must supply food according to the standards fixed by law. If they fail to supply the good food, quality food fit for human consumption, they will be held liable. So, law of torts in India is based on the common law of England. It is linked with the establishment of the British courts on India. The law of torts was introduced through British courts. The first British courts established in India were the mayor's courts. These mayor courts were established in the three presidency towns of Calcutta, Bombay, Madras in India. These courts were established in the 18th century. The law of torts are based on the principle of justice, equity, and good conscience. Because if an enterprise or a factory engaged in the hazardous or dangerous industry, he owes an absolute and non-delegable duty to the community. He is liable for the loss. Entire law of torts is founded structured on morality, and no one has the right to injure or harm or others intentionally or even innocently. Now, the definition of torts. Winfield definition and Salmon definition, they are two popular definitions. Winfield definition says he wrote a book called The Law of Torts. He defined torts. As per his definition, tortious liability arises from the breach of a duty primarily fixed by law. This duty is towards the persons generally, and its breach is redressable by an action of unliquidated damages. This definition we can bifurcate what it says. Law of torts liability arises from the breach of duty, and this duty is fixed by law, and duty is generally towards other persons. Its breach is redressable by an action of unliquidated damages. Winfield theory is based on the maxim there is no wrong without remedy. It is the elementary maxim. It says, where the man is wronged or damaged, he shall have the remedy. According to this theory, there is no tort without remedy. Law fixes certain duties on every person. At the same time, it grants certain rights to every person. These rights and duties are in rem. It is against the whole world. For example, I walk on road. It is my right to use the public road. There is a duty fixed on the public not to cause any harm or accident to me. This duty is applicable to the whole world. If any person breaches his duty, hits me with his vehicle, he shall be held responsible. Then what he has to do? Wrongdoer or person hits the vehicle is liable to pay compensation to the victim. Now the question is, how much compensation he has to pay? The court decides the quantum of damages according to the circumstances. The compensation is not fixed before the accident happens or before the tortious liability arises. It is not possible to fix compensation before the accident. So it is called unliquidated damages, not ascertained at the time of accident. Salmon's definition. He is another scholar. He says that tort is a civil wrong for which the remedy in a common law action for unliquidated image damages and which is not exclusively the breach of contract or the breach of trust or other mere equitable obligation. He says that law of tort is a civil wrong. Then what is the remedy? It is action for unliquidated damages. Civil wrong is not the breach of contract or breach of trust. It is merely equitable obligation. Salmon's definition is more elaborative and comprehensive. Salmon said, tort is a civil wrong. According to him, tort is not equal to breach of contract. Tort is not equal to breach of trust or any other obligation. Law of tort covers all civil wrongs in public life. When civil wrongs occurs, tortious liability arises. When when a wrongdoer does a civil wrong, he is liable to pay unliquidated damages. Fraser's definition, he says, tort is an infringement of right in rem of a private individual giving right of compensation at the suit of the injured party. General principles of torts and liabilities and theories of torts liability. Law of torts is a new branch of law. It is created by numerous judicial decisions. The courts adopted new ideas of social welfare policy. These new ideas have been recognized by the society and they are recognized by courts also. For example, for the law of negligence, Dino versus Stevenson is a leading case. It imposes tortious liability upon the negligent manufacturers. What is the Dino versus Stevenson case? Appellant went to wine shop, retail shop with her boyfriend. He purchased ginger beer for her. Bottle was dark. She consumed some beer. So she found decomposed body of snail and floated it. She brought the same to the retailer. She suffered in her health. Suit was brought against the manufacturer's bill. Manufacturer said he did not owe any duty to care towards plaintiff. The House of Lords held that manufacturer is liable for the negligence. They owed a duty to take care every consumer. Their product should not contain any harmful material. It is called as neighbor's rule. You must take care of, avoid injury to your neighbor. Who is neighbor? What is the duty of care? Manufacturer has to take care of consumer. Seller has to take care of purchaser. Owner has to take care of tenant. Doctor has to take care of patient. Owner has to take care of passenger. So, this is the leading case imposing tortious liability upon the negligent manufacturer. Another case is a strict liability. It is a Ryland versus Fletcher case. What is a Ryland versus case? Person is liable for the harm caused to the other if he has no intention or no negligence towards other. If no fault, then also it is a strict liability. In this case, Fletcher employed a contractor to construct a reservoir for storage of water. And a reservoir, disused shafts were there. Contractor did not fill the shafts properly. So he completed the work. Water overflowed. Water entered the coal mine of the Ryland. Ryland's work stopped. He sued for damages. Fletcher said there is no negligence. House of Lords said it is you are liable to pay damages. What is the rule here? Person who brings in his land and collects anything to do mischief, if it escapes, he must keep it as its peril. Otherwise, he is liable to pay damages. It may be explosives, poisonous drugs, gas, machinery, or dangerous article. Another likewise strict liability in the case of environmental pollution cases, Bhopal disaster case, a Supreme Court adopted the absolute liability principle. Union Corporation versus Union of India. On the night of 3rd December 1984, dangerous gas was leaked from the pesticides plant situated at Bhopal. Plant belonged to Union Carbide Corporation. As a result of leakage of gas, about 3,000 persons died and 6 lakhs persons displaced suffered permanently. So, Supreme Court gave the judgment ordering the defendant to pay 750 crores, 650 crores, 750 crores to the victims and the dependents of the diseases. Likewise, in addition to that, there are various modern principles and rules created in the field of torts like a polluter pay principle. Now, theories of liabilities of the torts. There are two important theories, Winfield theory and Salmon theory. Winfield theory, he wrote a book called as Law of Torts. He asserted his views based on the maxim ubi just ibi remedium. It means there is no wrong without remedy. It is an elementary maxim. It means when the man is wrong or damaged, he shall have the remedy. According to this theory, there is no tort without remedy. There is no need to open separate rule for every title of acts like assault, nuisance, defamation, etc. Only one title, law of torts, is sufficient to cover all the titles and branches. Another theory is the Salmon's theory. This theory propounded by Sir John Salmon. It is known as Salmon theory. It is pigeonhole theory. He says, according to him, there are many pigeonholes in pigeon nest sufficiently to occupy the holes. For new pigeon, there is new hole. Separate hole has to be constructed for a new pigeon. Similarly, there are many kinds of injuries or harm. There must be so many tortious liability. There is no single liability. Certain principle should have to be framed. Now, Supreme Court, following the Salmon's pigeon hole principle in respect of decisions in environmental pollution cases.